All right, I think we're going to go ahead and get started. So now I'd like to introduce our second panel, Sharia Law, what it is, what it isn't, and what role it should have in our courts. The moderator for our second panel is Professor Mark Drumble. He is the class of 1975 alumni professor here at Washington and Lee, where he also serves as director of the Transnational Law Institute. Professor Drumble's research and teaching interests include public international law, global environmental governance, international criminal law, post-conflict justice, and transnational legal process. We're very fortunate to have him here as our moderator. So without further ado, I give the floor to Professor Drumble.
Thanks, Monica, and I'd like to thank all the staff, everyone who's been involved in putting this together, along with the speakers. It's really a fantastic event, and I'm very proud to have students, colleagues, and friends of the law school willing to come together today to talk about Sharia law, what it is, what it isn't, and what role it should have in the courts. I'm going to introduce each of the four speakers, and then I gather there is a timekeeper. All right, so, and the timekeeper will do just that, keep time. We're going to have four speakers, so 20 minutes each, and that'll leave about half an hour, a little less, for Q&A. Our first speaker is Hamid Khan from the United States Institute of Peace, where he is the Senior Program Officer of the Rule of Law Center. He works on rule of law issues regarding Afghanistan and teaches a training course on Islamic law with the Institute. He is also a professorial lecturer of Islamic law at the George Washington University Law School. Mr. Khan has lectured on Islamic legal matters around the world. There's a long list of places where he has spoken, including institutions such as the NATO School, Stanford Law School, and Northwestern Law School. Currently, he also serves as an advisor to NATO on issues of Islamic law, counterinsurgency, and empowering women under Islamic law and theology. Our second speaker will be Asma Udin from the Beckett Fund for Religious Liberty and founder and editor-in-chief of altmuslima.com. Did I get it right, or will you correct me?
Yeah, you got it right.
Thanks. She has spent her first few years at the Beckett Fund, serving as the primary attorney for Beckett's Legal Training Institute, which is devoted to working with local partners around the world to train advocates, lawyers, judges, religious leaders, journalists, and students in religious freedom law and principles. More recently, she has taken on the role of legal counsel, where she defends religious liberty in the U.S. through several prominent cases at the Beckett Fund. She's also the founder and editor-in-chief of the website that I got once right the first time, and I won't say twice, and as a web magazine dedicated to issues on gender and Islam. Our third speaker to my left is Amara Chowdhury at the Council on American Islamic Relations in Philadelphia. Ms. Chowdhury has dedicated her legal career to the struggle for civil rights and equality and focuses her practice at the intersection of law and race, religion, gender, ethnicity, and national origin, particularly within the context of the criminal justice system. She currently serves as the Civil Rights Director and Staff Attorney for the Council on American Islamic Relations, in a position where she focuses her practice on governmental discrimination against American Muslims. Her ongoing projects include anti-Sharia legislation in Pennsylvania and nationwide, anti-Muslim profiling by the NYPD, security clearance denials in the context of federal employees, and the official non-engagement policy of the FBI against Muslim organizations nationwide, as well as discrimination issues in the state and federal prisons and by private employers. Our fourth speaker, to my far left, is my good friend and dear colleague, Professor Robin Wilson, who is the class of 1958 Law and Alumni Professor of Law and has served in the Law Alumni Faculty Fellow positions, honoring the quality of her scholarship. Her BA and JD are from the UVA, and before entering practice, she clerked on the Fifth Circuit. Her specialties involve family law and health law. She's the past chair of the AALS section on law, medicine, and healthcare, and also family and juvenile law. Professor Wilson is a member of the American Law Institute. In 2010, she was ranked among the top 10 family law scholars in the United States in scholarly impact. And let me add to what is not written here, Professor Wilson has constantly lectured nationwide on a broad variety of issues and maintains an extremely high profile on legal matters and also broader public policy circles. I'll stop. The speakers will start in their order, and let's welcome them all now to Lexington.
Good afternoon. I want to first of all thank the Journal for the kind invitation and obviously trying to do justice to a legal system that has spanned 14 centuries and affects the lives of 1.5 billion people can easily be accomplished in 20 minutes, so I'll give it a try. Basically, as we have already discussed so far, terms like the word Sharia have become a dirty word in America, and so hopefully in the few minutes I have, we'll parse out some of the distinctions and what it is and what it is not. But first and foremost, even the term Sharia is a controversial one. The word, by the way, is only mentioned once in the holy text of Islam, the Quran, and literally it means a path to the source, specifically a source of water. Now, for those of us who have studied Islamic law, who studied the language of the Quran, it is clear to us that the word Sharia is not the same as what is often used, because everyone sort of subsumes that the word Sharia is immutable, it is unchangeable, and it is very much something that is clear and evident, and all of those things are not true. The word Sharia only appears once in the Quran and only refers to a straight path. But what that path really is really a path in religion. It is the divine law. But any examination of the history of the Quran itself reveals that there are very few things that are outwardly evident, that even upon introspection, through time, manner, and place, reveal itself to be abundantly clear. So when we talk about the term Sharia, we are really talking about God's law. We are talking about a divine law. And the reality is, most of what we have seen, most of what we understand that to be, is probably better understood as Islamic law. So today, when I speak of it, I will speak in two periods. A period from the time of the Prophet to the age of the classical era, and then more the modern era of what our impressions are of Islamic law. So, to begin where it all began, we have to go to Arabia. The middle part of Arabia. In the 6th century, by a nomadic group, and by one man, Muhammad. And it really basically is cemented around the idea that God has intervened in the role of humanity, that God has directly intervened, and that specifically, it took the form of a revelation. The revelation we know as the Quran, which means, by the way, the recitation. It's about the size of the New Testament. And what's interesting about the discussion about the Quran is it did not come all at once. It actually came over the course of an entire generation, specifically 23 years. It also was in many ways, and to Muslims today, regarded as the very Word of God. And as we'll speak about that, that issue about it being treated as the Word of God is one of the central issues about how Islamic law has unfolded through history. But what is important is that Muhammad was a man described as unlettered, but he, in a generation, would lead one of the greatest movements in modern humanity. And that movement, of course, affects us today. Now, if one looks at the content of the Quran, less than 4% of all its verses are actually dedicated to legal matters that affect most situations outside of ritual practice. Most of Islamic law is actually dedicated to the concept of prayer, of giving of alms, of the pilgrimage to Mecca, the type and laws that are purely confined to the believer as they are and confined to their ritual practice. In other words, laws are not the mechanisms of the state, at least not until recently, except by groups like the Taliban. But what does remain of the Quran are enduring messages about the judgment of God, about His nature, about the nature of judgment, about His compassion, about mercy. As was earlier pointed out in the panel, one of the discrepancies about people's understanding of Islam is that they simply don't know. People often don't know that, for example, the most often mentioned figure in the Quran is Moses. The second most often figure is Jesus. And the Virgin Mary is actually more mentioned in the Quran than in the New Testament. So when one looks at the Quran, when one examines its contents, again, assuming that those contents yield itself to be clear and evident, they will find that there are many familiar topics. And when it comes to areas such as law, or what we consider legal injunctions, most of them touch upon very general principles. The contract should be upheld. The consent should be derived. That people should uphold their obligations truthfully and freely. That people should attest to matters in wills that are written. And that evidence be used to confront individuals, and if there is no evidence, they should not be used. Basic principles. Principles enshrined, again, in the 6th century. Now, without going into too much detail, when the Prophet died, there was a question as to what do we do now? Because in Muhammad, the individual, the collective Muslim infant population that it was, numbering from a beginning of just a few close relatives, and more importantly, the Prophet's wife, Khadijah, had become something far and away more momentous. And that community was left with a basic question: what do we do now? How do we organize ourselves? But this movement of Islam, this religion of Islam, would not stay confined to that part of Arabia. Soon it would expand. It would expand northward. It would soon, within another generation, rival the size of the Roman Empire. So, again, the early leaders were tasked with the question of, well, we have the Quran, but we still have to figure out how we live according to the laws and dictates of that. And so for the first century of Islam's history, there was a debate, a recurring debate. Is this book the Word of God, eternal with God, or is it a created document? Is it a document that is responsive, that was responsive to the situation in Arabia, to the customs that existed? And that debate plagued many who debated this issue. Because if it is the eternal Word, then the question of its mutability becomes a great deal more important. And if it's responsive, then how do we look at law as responsive? Responsive to the plight of the people, responsive to the plight of the individual. So as time would go on, the sources of Islam's legal system became crystallized, and there was a heavy nod towards the idea that this is a miracle unto itself. It is the miracle of God's Word, and therefore should be treated as such. But what also became true is that the Quran, for all of its discussion about a variety of matters, actually discussed very little about law, and the question then became, who do we look to? Who is going to be the source of that law? And then those individuals turn to the legacy of the Prophet Muhammad. How did Muhammad decide these matters? Why did he decide the way he did? And in what ways did we, and how are we to emulate the Prophet's example? And from there, we basically, in a century and a half, had basically articulated within the Islamic legal system two major sources. The Quran, as the revealed Word of God, and the tradition of the Prophet Muhammad. A tradition that would look upon him, look at his actions, provide context to the words of the Quran, provide reasons for why some of the rules prescribed in the Quran, such as polygamy, or other issues about retaliation or criminal laws would all become enshrined in those words. And those narratives would become part of the articulated message of what do we do, how do we govern, how best do we judge one another in this society. A growing society. A society that was no longer mostly Arab, but now we're dealing with Persians. We're dealing with other individuals of different ethnicities. And here again, the governors and the early rulers were faced with an issue. So with that sense that the Quran was the Word of God, and with the sense that here was this prophet, a prophet endowed with the message of the Word of God, they began to articulate a theory that says we look to these sources first and foremost, and from those sources we yield the answers to those questions. But if we fail to yield those answers, we would look to the rules to give us inspiration and to analogize how best to figure out the law from there. In other words, from the beginning of the Quran, which laid down a few set of rules, we expanded the scope so that it would look to the Prophet's example. It would look to how the Prophet, for example, dealt in matters of diplomacy, how the Prophet Muhammad dealt in matters of international treaty obligations, or how even the Prophet drank a glass of water. So from there, a whole body began to be established. A body not of those who would just merely decry what religion is, or merely take a verse from the Quran and say, aha, I found what the law is. But they had to be educated. Within another century, Islam's institutions had developed the requirement that those who expounded upon the law would have to have anywhere between 4 and 14 years of training. And that the key to that training was an examination of language, an examination of context, an examination of the precedents of other legal scholars, in order for them to even approach the right to interpret the law. So in other words, not entirely unfamiliar to law schools here in the United States, not entirely unfamiliar to institutions where law is appropriate. We don't go to any person on the street and say, well, what's your interpretation of the law? In the Islamic legal system, you had to have a sufficient criteria, a sufficient number of years of training about what the meaning was, in order to then expound upon how to extend that meaning to everyday life. And that becomes of critical importance when we talk about what Islamic law is today. Now, for centuries, this paradigm had basically devolved around a juristic class, a group of individuals who were scholars, academics, if you will. And more importantly, they sat outside the institutions of politics, intentionally so. Because their loyalty to the law was not the loyalty to the politician who occupied the seat of power, whether that be in Baghdad or Damascus or wherever the empire was, or whatever imperial state that the Muslims had at that time. Their position was, our loyalty is to God. Our loyalty is to ensure that any approach to the divine law was to be kept outside of politics. But inasmuch as they were trying to avoid political considerations, they were actually also devaluating their own opinions. For as much education as they would claim to have, and for decades of time spent studying the text and the language, their views were simply theirs. In other words, under Islamic law, one's interpretation, even however scholarly, was but an interpretation, their quote-unquote understanding of the law. And in Islamic law, we call that parlance fiqh. In other words, through the filter of education came an understanding, but that understanding was but one jurist understanding. And one could accept it if one wanted, and unless they were in a court or obliged by a judge, they could choose, freely choosing which opinion was acceptable. So it was in that broad penumbra of diversity and accepting the views of the jurists who were the most learned that Muslims took their guidance. Should they do something? Should they act accordingly? How should they do? How should they act in this particular situation or not? Now, at the same time, the politician, the caliphate, the political successor to the Prophet, also had a body of laws, had a body of authority conferred unto him, where he had to look to the law and try to find out, well, in the pursuance of Islamic law, what do we do with traffic laws? Because there's no mention of traffic laws in the Quran. And so the caliphate had his own reservoir of authority. But in each, there were different separation. A separation of authority, a separation of understanding, and most important, the demand that any interpretation of the law be both qualified, be diverse, and perhaps most importantly, implicitly accepted. That there be no one universal interpretation of any particular area of law, and then most importantly, that Muslims are encouraged to give freedom to those interpretations. And that Muslims be allowed to freely interpret what that is. Now over time, however, and this system lasted for several centuries. Over time, however, the Islamic world became under different threats and eternal decay and its own bureaucracy. And so the legacy of a system based upon scholarship, a system based on linguistics, a system based upon freely choosing, started to come under a historical threat. And eternal reforms meant, well, let's look to Europe. And that European model was codes of clear, decipherable, but single-dimensional approaches to the law that reduced the freedom of interpretation and the freedom to interpret the law to a singular linear provision. This is what the law is. Rather than a diverse group of different opinions that one could freely choose from. So the Ottomans, along with other Islamic imperial states, had begun to codify their laws. And the juristic class began to be reduced in their emphasis. So rather than have a body of jurists who would be able to interpret the law, you now had laws in single form. And from the period of 1923 to the 20th, now at the end of the 20th and 21st centuries, Islamic countries, Islamic states, and non-Muslim countries have had to contend with a law that is singular and one-dimensional, that states what God's law is. So in many ways, what you actually see is more of a Sharia-based idea because it takes out discretion. It takes out the freedom of ability to choose and to have different varying opinions of the Islamic world and the words of the Prophet Muhammad and that of the Quran. Today, we live in a very different era. It was once remarked that democracy had faded into history and would be no more. And when the Greeks decided that democracy wasn't going to meet the perils of history, many thought it wasn't going to come back. But it wasn't until the 18th century when we saw that the re-idolization of democracy became ascendant. Now, by the way, no one today is saying we want more monarchies. But the same occurred with Islamic law. Many believed that Islamic law would go through the dustbin of history, that the religious laws that were in place actually would stay that way. Except that in this era, in the past 60 to 70 years, Islamic law has made a serious resurgence. It has become the articulated law of a number of different states in a number of different forms. Most commonly, it takes the form of family law or private or personal status laws. And that not only extends to states that have Muslim majorities, but also non-Muslim majorities. Places like Israel and India have codified articulations of Islamic law, and specifically to family law. But today we also live in an era where the scholarship of Islamic law is no longer in the hands of a few academics or of a few non-political elites. Now the institutions that once shaped Islamic law are in the control of politicians. And whether it be in Pakistan or whether it be in traditional areas of the Muslim world, what we understand Islamic law to be is now the province of politicians. Institutions have largely failed. And the demand for Islamic law is not really a demand for Islamic law as it is a demand for authoritarianism. If one looks at the situation in Mali, the Taliban, Boko Haram in Nigeria, and others, you see the central plank being that we need to establish Sharia law. And that usually comes in the form of the criminal aspects of the law. But what isn't mentioned are all the procedural requirements, all the evidentiary requirements, all of the things that accompany Islamic law and the classical tradition. Instead, now it becomes a political football, used by states, especially in the Muslim-majority countries, to establish authority, to confer legitimacy, because they often lack legitimacy. So when you look at the totality of Islamic law, you're looking at a centuries period of time. You're looking at institutions, and you're looking at its revitalization, but in a far different world. So keep in mind that when one looks, for example, to the laws of the Bible, when one looks to the laws of any text, when one looks at language, which you are all going to confront as either lawyers or up-and-coming lawyers, language is often oblique. And to draw meaning from language often requires context, understanding, and an embracing of different interpretations. That was one of the foremost principles of Islamic law, and hopefully that will give you some sense about how Islamic law is to be understood and how it is likely to be understood in the future. Thank you.
Thank you for that. So during my talk, I'm going to start by describing the various categories and types of anti-Sharia laws that have been proposed in various states. And then I'm going to do a brief analysis of those laws under the Establishment Clause and the Free Exercise Clause of the First Amendment, and to show the types of issues and problems that raises, and then ultimately then end with going a little bit into analysis of how, even though there's all these problems created by these laws, in fact these laws are created to solve a non-existent problem. So in other words, there isn't really a need for them, but now that we have them, there's all kinds of other issues that are popping up. So during the last panel, the Center for American Progress report, Fear Inc., was discussed. This report defines what is the Islamophobia industry in this country. The report starts by defining Islamophobia, which it says is an exaggerated fear, hatred, and hostility toward Islam and Muslims that is perpetuated by negative stereotypes, resulting in bias, discrimination, and the marginalization and exclusion of Muslims from America's social, political, and civic life. It then goes on to discuss the 5 key individuals and organizations that are pushing this agenda. They are people whose names and organizations whose names that you, like most Americans, won't know, they're not familiar, but they're definitely having a concrete influence on the national and international debate and discourse related to Islam and Muslims. And so these guys, who the report calls the misinformation experts, are advancing a notion of Islam as an intrinsically violent ideology, the goal of which is to achieve dominance over America and over all non-Muslims worldwide. And they seek to define Sharia as a totalitarian ideology and a legal, political, military doctrine committed to annihilating Western civilization as we know it today. It's pretty extreme rhetoric, but it's definitely having an effect, unfortunately. And one of the effects that we see is the promulgation of these anti-Sharia laws. So there are 3 categories of anti-Sharia laws. The first category includes those that single out Sharia specifically from all other legal traditions and describe it as anti-American and treasonous. A prime example of this type of legislation is Alabama's proposed but now dead bill, which stated that a court shall not look to the legal precepts of other nations or cultures. Specifically, the court shall not consider international law or Sharia. So the second category mentions Sharia specifically, but mentions it as one of several different types of legal traditions that should not be permitted. For instance, the Arizona bill says that courts are forbidden from considering religious sectarian law, which it goes on to define as including Sharia law, canon law, halakha, and karma. And finally, the third and most frequently seen type of bill is the type that outlaws any reliance by the courts on foreign law. It does not mention Sharia specifically, and they define these types of bills define foreign law as any law, rule, or legal code or system other than separate from the state and federal constitutions, state and federal law, and the ratified treaties of the U.S. So in today's presentation, I want to focus in on one of these laws, and that is the Oklahoma International Law Amendment, which was on the November 2010 general election ballot as a legislatively referred constitutional amendment. The ballot initiative was approved by Oklahoma voters and fell into the first category of anti-Sharia laws, so it specifically mentioned Sharia and singled it out for specific disfavor. That same month, Munir Awad, represented by the Council on American Islamic Relations and the ACLU, filed suit challenging the law. And the U.S. District Court blocked the measure, saying that any sort of harm that would result from a delay in certifying the election results was minimal because the legislatures could not show even one instance in which Sharia had in any way led to any problems. So in other words, going back to this idea that it was a solution looking for a problem. In January 2012, the 10th Circuit Court of Appeals upheld the district court, and there was little activity on this in the 2012 Oklahoma legislature, but 2013 finds a new effort filed as House Bill 1486. This version does not specifically mention Sharia and falls closer to the third type that I mentioned earlier. Now, in the course of for the purposes of my analysis today, I'm going to be focusing on the earlier version of the bill, the one that did mention Sharia. And I just wanted to briefly first set up like the constitutional framework, for those of you who don't have too much background on that. So first, there's the Establishment Clause. And the purpose of the Establishment Clause is to protect religion from state overreaching. It protects both minority and majority religions. It protects minorities specifically from both state encroachment, but to the extent that that might come through with use of the democratic process by either a secular or a religious majority. And of course, like I said earlier, it protects both majority and minority religions in general from state interference. And there are various legal tests used to assess whether or not a law violates the Establishment Clause. But in general, we're all familiar with three prongs of the Lemon test. The idea is that the intent behind the law, the primary effect of a law, cannot work to disfavor or favor a particular religion, and ultimately cannot also entangle the government in religious affairs. Under the Free Exercise Clause, protection for religious beliefs are absolute when it comes to actions, that the exercise of religious belief. There's wide protection. There are some limitations, but there's wide protection. Generally seen in the form of exemptions to laws. The idea generally under the Free Exercise Clause is that if there are exemptions for secular conduct or for religious conduct, particular religious conduct, then you cannot then disfavor other religious conduct. In no way can the state favor secular or specific religious motivations over other religious motivations. And ultimately, if it does, it must satisfy strict scrutiny, which means that the government must demonstrate a compelling interest and the law must be narrowly tailored to serve that interest. So thematically, the Free Exercise Clause requires the state to give citizens discretion in ordering their lives according to their religious beliefs, absent a compelling government interest to the contrary. So arising from the Establishment Clause and the Free Exercise Clause is a doctrine called the Religious Question Doctrine. So ultimately, the idea is that under the First Amendment, that government and state are two separate, they kind of exist in two separate spheres, and that is for the protection of both. So it's protecting government from religious incursions and religion from government incursions. And ultimately, the way this works, on the one hand, is that civil courts cannot get into. So the way it deals with religion. So on the one hand, you can engage in fact finding in order to determine whether or not a particular doctrine or practice is religious and thus deserving of protection under the First Amendment. On the other hand, civil courts cannot get into the question of actual religious issues. You can't get into it substantively and try to decide what is the right religious interpretation on a given issue, for example. And the reason for this is because American civil judges are not competent to do that. They're not religiously experts. And so this isn't something that they need to be getting involved with. And more importantly, they do get involved in it. What it'll lead to is the fact that they'll decide in favor of one interpretation over another, and thus imposing one version of the religion on dissenters within the religion. So given this already existing constitutional framework, and the fact that the Supreme Court articulated this principle very early on, it's a bit suspicious now that we're seeing laws that are trying to solve the problem of judges considering religious substantive law. Because that problem has already been taken care of. It's already addressed by the Constitution. So how does the Oklahoma law fare under this constitutional framework? So looking at Awad's lawsuit, he had an Establishment Clause claim. He said that the Oklahoma ballot initiative provided that Oklahoma courts shall not consider international law or Sharia law, and that the courts may not look to the laws of other states if those laws include Sharia law. It describes Sharia law in definite religious terms as Islamic law based on the Quran and the teaching of Muhammad. Thus, Sharia law is the only particular body of law specifically prescribed by this amendment. Awad argued that the Oklahoma ballot initiative labeled him a political and social outsider because of his Islamic practice and belief, characterized his Islamic religious beliefs as a threat from which Oklahoma must be saved, and conveyed the unmistakable message that his Muslim faith is officially disfavored by the state generally and the judicial system in particular. And his free exercise claim, he argued that Muslims, out of all the other religious groups in the state, were singled out for special disfavor. Unlike any other religious groups, they are the only ones who had to scrub all religious terms from their legal documents. Specifically, he argued that the proposed amendment interfered with the operation of his last will and testament. Because his will refers to and incorporates his Islamic religious beliefs, the amendment would render those will provisions unenforceable. The presence of the amendment created a cloud of uncertainty over the will's full enforceability because of its religious references. So in addition to Awad's claims, there's a number of other things, a number of other hypothetical scenarios that I can pose for you that demonstrate some of the problematic results of laws like this. For instance, consider a situation like an employment contract where an employer agrees to, for instance, allow an employee to go on the Hajj pilgrimage, or to come in on different timings during the Ramadan. So Ramadan is the month in which Muslims fast from dawn to dusk. And maybe an employer has agreed in the contract that you can come in at different times, maybe after you break the fast, so on. Again, in order to enforce this contract, the court doesn't have to get into the nitty-gritty of Islamic law, but does have to understand what the meeting of the minds was. What was the issue that they agreed to? And that refers to some basic reference to the Sharia principles at issue. Another type of contract might be that an employer has, or somebody has decided that they're going to pay for your Hajj pilgrimage, for instance, or to cover the expense of some other religious obligation. Again, the court does not need to get into any substantive issues, but does have to have a basic idea of what exactly Hajj pilgrimage is, which then refers to some basic understanding and fact-finding related to Sharia issues. Not only do these laws prohibit this sort of fact-finding, but it also creates a question of discrimination. So if there was a similar contract involving either non-religious obligations or religious obligations of people of other faiths, those types of contracts could be easily enforced. Similarly, such a law would limit a judge's ability to craft equitable remedies. So in the course of coming up with remedies or sentences, a judge often has flexibility and the ability to look at both public and private needs. In the case of a Muslim, the judge wouldn't be able to do this because some of those private needs might in fact include their religious obligations. So again, a basic sort of reference to Sharia principles is, by the terms of these laws, completely forbidden. An example of this might be, for instance, if they're trying to determine like community service hours or a visitation order in the context of a custody dispute. If a Muslim needs to lay out, well, this is kind of my schedule and my timetable in terms of my religious obligations, those sorts of things wouldn't be allowed. That's something that the judge can consider. And finally, such a law would provide unequal protection for persons who make use of Islamic arbitration. Now, the law itself does not prevent the use of Islamic arbitration. People can still engage in it. And some Muslims in the U.S. do engage in it for the purposes of family disagreements, inheritance, business disputes, marriage and divorce issues. So again, nothing in the law prevents the use of an arbitration, the process of arbitration, but once a person does engage in it, not only does it impact the enforceability of the decision of the panel, but furthermore, takes away the protection the civil courts provide in terms of making sure that, for instance, so a civil court is the only court that can enforce an arbitration decision. And before a civil court enforces it, it has to look, for instance, for both substantive and procedural fairness. And there's certain checks and balances, and it makes sure that it isn't a grossly unfair result, for instance. And so those sorts of protections are denied to Muslims who might want to engage in arbitration simply because judges can't look to Sharia. So what I propose is that instead of enacting laws that, again, solve a problem that doesn't exist, that we let the American legal system do what it always has done, because it's actually always worked very well. When dealing with contracts written with Sharia principles in mind, civil courts have always only referred to Sharia as a tangential issue, instead focusing on issues within their competence, such as the basic principles of contract law. The crucial feature of any kind of arbitration is that an arbitrator, whether religious or not, has no ability to enforce the arbitral decision. Only state or federal courts have that power. In deciding whether to enforce arbitral awards, civil courts first review whether the parties agree to take part in the arbitration of their own free will. Courts also review the decision to ensure that arbitrators are neutral and that the resulting decisions are neither grossly unfair nor undermine public policy. And so, as I mentioned earlier, there are these already existing checks and balances and very carefully crafted safeguards that protect and protect against any sort of incursion of the scary sorts of things that people claim Sharia imposes. For example, in a couple of case examples. In one case, the federal district court honored the contractual choice of law provision at issue, which designated Saudi law. The court accepted that it is apparent that Islam permeates every aspect of life in the Kingdom of Saudi Arabia, including its legal structure. Saudi law limits damages for breach of contract to losses which are actual and direct, such as for actual physical harm to property or out-of-pocket losses. This is based on the Islamic law principle that damages can be obtained only for losses that are certain. Despite its foundations on Islamic principles, the Saudi law is enforceable without reference to religious doctrine. As such, the court applied Saudi law because doing so did not entangle the court in religious questions. Similarly, there's a number of cases that involved an agreement for the meher. So the meher is a dowry that is paid by the husband to the wife, and if it's due and payable in the instance of divorce if it hasn't paid at some point earlier. And so in dealing with this question, courts have approached it again, from the framework of the legal safeguards that are in place, but the results have been different. For instance, in Oratala v. Oratala, a case in the Superior Court of New Jersey, a meher agreement was upheld. The court determined that enforcing the Sharia-based agreement raised no First Amendment concerns because this action was based on neutral legal principles of contract law rather than religious policy or theories. In contrast, the court did not uphold a meher agreement in another case called Zahawarkiri v. Al-Watar because it concluded that the husband had entered into the agreement as a result of overreaching or coercion. So because he was embarrassed and he felt really coerced into agreeing to a certain amount in the meher agreement, the court held that because it was done under duress, again, applying basic contract principles, that the agreement was not valid. So again, just to sum up, what I hope to demonstrate was the fact that there are all these issues that come up. There's so many different potential hypotheticals. I offered a few of the way that these types of laws could create major constitutional issues, and it seems very unnecessary given the fact that there is no need for these laws to begin with, given our existing constitutional framework. Thank you.
All right. Good afternoon, everybody. I'm going to begin by actually telling you about how my speech today will follow upon my other panelists. So Hamid spoke very eloquently, of course, about Sharia law itself. I will not be discussing Sharia law itself. However, I will be following Asma's discussion of so-called anti-Sharia bills. These are bills that have been introduced in various states here in the United States to guard us against the perceived threat of Sharia law coming into our courts and taking over our legal system. Specifically, I'm going to speak about my own experiences challenging one such bill in Pennsylvania. And my bill was actually introduced following the Oklahoma legislation, which Asma described earlier. Now, before I begin, once again, I'm going to go over some definitions. These bills have generally been described as so-called anti-Sharia bills. And I say so-called, I've always put anti-Sharia in quotation marks when I've written about it, because that is a label that has been used by the proponents of this legislation, basically to target and to demonize Islam and Muslims. I know that the organization for which I work, the Council on American Islamic Relations, has used the term anti-Islam to show that these are bills not targeting a body of law, but targeting a faith itself. And I myself prefer the phrase anti-Muslim bills because I believe that these bills target a people, a distinct group of Americans. So I think the slight distinctions. But I wanted to tell you guys as a broad overview, to date, as of Wednesday when I was last in the office earlier this week, 78 bills had been introduced in 31 states and 6 had passed. Bills had been passed in Arizona, Tennessee, Oklahoma, Louisiana, and Kansas and South Dakota. Bills, by the way, have been introduced here in Virginia. At the time I became involved in this issue, more than 50 bills have been introduced in 23 states. And yet, miraculously, the first time I had ever even heard of such a thing, and of course I've been Muslim for a pretty long time, close to 4 decades, and yet I had never heard of such a phenomenon as these bills. And the first time I heard about it was when a bill was introduced into the Pennsylvania House Judiciary Committee with this seemingly innocuous title, American Laws for American Courts. Now, of course, I looked at the bill, kind of glanced it over, and I wouldn't even have thought to be upset about it at all until one of my colleagues showed me the co-sponsorship memo that was drafted by the bill's sponsor, Representative Rosemary Swanger from the ironically named Lebanon, PA. Lebanon, PA, by the way, no Arab connection, founded by German immigrants, but Bethlehem as well. But I just wanted to throw this out there. And I looked at this co-sponsorship memo, and I will tell you what a co-sponsorship memo is. When a member of a state general assembly is proposing legislation, they then send a memo out to all of their colleagues in both the House and the Senate and say, please support my bill for whatever reasons. And it's usually between 1 to 3 pages, short memo. And this memo itself, in its subject line, it was pretty obvious that this was not just generally saying the obvious, that we live in America and American law should be in our courts. Because the subject of the memo says, proposed legislation, and then in bold, American and Pennsylvania laws for Pennsylvania courts, -- Sharia law. So they made it very clear there. I start skimming. The words Sharia law are peppered throughout. No mention of canon law, Holocaust, Jewish law. I know Asma mentioned it, Arizona Bill Karma. None of that. The Sharia law all over the place. And of course, the first paragraph guards against what this bill sponsor called the incursion and infiltration of foreign law in Pennsylvania courts, which apparently was becoming an increasing problem. What really caught my attention, though, was as the memo continued, it talked about foreign laws which were increasingly finding their ways into Pennsylvania courts, including, and I quote, Sharia law, comma, which is inherently inconsistent with our constitutional liberties. This was sent out to every member of the Pennsylvania General Assembly. Now, so I see this memo, and again, at the time that I was aware of this bill coming into Pennsylvania, there was no press. This kind of occurred under the dark of night. And I did some research. I learned that 4 states had passed bills attempting to target Sharia law. At that time, it was Arizona, Tennessee, Oklahoma, Louisiana. All of those states at that time were being somewhat obvious about the fact that they were targeting, if not all religious laws, then at least specifically Sharia law. Either in the text itself, Arizona mentioned several faiths, Oklahoma mentioned Sharia law, but in preambles, in public statements of elected officials. So also as I get involved, the Oklahoma bill was already being challenged in federal court. And in Oklahoma, you had the bill sponsors making public statements saying they needed to protect Oklahoma. It's called the Save Our State Amendment, about these dangerous Muslims who were moving into their neighborhood. And the Attorney General likewise was talking about how he was going to fight this all the way to the United States Supreme Court. Now, in Oklahoma, CARE wanted to challenge the bill. They were looking for a plaintiff. And I think it's very important to realize that Munir Awad, my colleague there in Oklahoma, who was the executive director of CARE Oklahoma, said, hey, I'm your perfect plaintiff because I am personally affected by this bill. I have an Islamic marriage and an Islamic will. Now, this was, of course, great because the strategy out of CARE National is to prove that these bills actually affect individual lives. And it was actually, it's kind of hard in America to find a Muslim that has a Muslim marriage and a Muslim will. This is just not, we don't practice Sharia law in real life. Although it is threatening to take over the American court system, so it's kind of amazing. And so, this is what they moved forward with, and there was kind of this Establishment Clause argument tacked on, because we didn't want to overlook anything. And I remember going to CARE National, and they said, well, who's your plaintiff if this passes in Pennsylvania? And I said, what are you talking about? I'm your plaintiff. And I don't have an Islamic marriage or an Islamic will. They were very concerned. But it's the distinction between the Free Exercise Clause and the Establishment Clause that makes the difference. One, we were a facially neutral bill in Pennsylvania, and two, I don't think that these bills were ever designed to target religious practices at all. I believe they were designed to demonize a people and to let America know that Islam is not an American religion. So I said, I'm Muslim as much as anybody else, and your perfect plaintiff is the woman you just recruited from the LGBT rights practice. But anyway, we move forward as that litigation developed. What's interesting is, as an organization, we picked the plaintiff we thought was personally affected, and that was really sort of what we thought was our key argument. However, when the Fifth Circuit issued its ruling affirming the lower court's decision, most of the opinion actually talks about things such as mootness and ripeness, whether the issue is ready to be decided by the court. And those of you who've had con law know that you spend the first few weeks talking a great deal about something you think will never matter in real life. I will tell you, this entire decision kind of reflected upon that. And the court specifically said that Munir won not because, there was some language about the fact that he was affected, but the injury itself was that as a Muslim, his government had just told him that his religion was not, and adherents of his religion, were not part of the American community and the American political process. So it was very much, the language sounded very Establishment Clause-like, even though it was decided on mootness, ripeness kinds of grounds. Now, following that loss in Oklahoma, the people who got together and decided to pass all these bills, and Horace mentioned it earlier, Osmar alluded to it, there is actually a body of individuals that gets together and tries to do things to target Muslims. An organization was formed called the American Public Policy Alliance that created the model legislation known as the American Laws for American Courts. And when they created this, they actually did a lot of press, including on their own webpage, chastising Oklahoma and saying, the problem with Oklahoma is that they weren't smart enough or savvy enough to make their bill facially neutral. The author of the model legislation, and now he's openly acknowledging the fact that he's the author, an attorney from Brooklyn, New York, named David Yerushalmi, actually has been quoted in the media as talking about the fact that there's a need to avoid what he called the sticky problems of our First Amendment jurisprudence. So they actually acknowledge that they're trying to circumvent American con law because it is unconstitutional to target a particular faith. They know this. And he also has acknowledged rather recently that it's never been his design to pass these bills. The goal of introducing this legislation is to start a dialogue and to demonize a faith. And when you look at the model legislation, it contains some of the language I quoted to you from the Pennsylvania legislation regarding against the infiltration and incursion of Islamic Sharia law into our courts. And if you believe that the nativist, xenophobic sentiment could be there, but you're not really sure, I want to actually quote for you some things that have been reported about the author of the bills. The New York Times has reported that the author has been quoted as saying, and I quote, most of the fundamental differences between the races are genetic, end quote. That, open quote, there's a reason the founding fathers did not give women or black slaves the right to vote, end quote. And the ADL, the Anti-Defamation League, has quoted him as saying that African Americans are, and I quote, a relatively murderous race killing itself. And finally, that America was the handiwork of faithful Christians, mostly men, and almost entirely white. So this is the rhetoric of the people who drafted this bill. So it comes from a history of hate that extends beyond Islam and Muslims. But when this legislation was drafted, the proponents actually had made some public statements, and where they wanted to do this was in the Commonwealth of Pennsylvania. Now, why Pennsylvania? Now, back when I was here, I know that Ann Massey had a wonderful common law seminar about the religion clauses. 14 weeks, nothing but religion clauses. I thought it was great. You should all petition to have it back. But anyway, what I learned growing up right here, actually not far from Lexington, was that Pennsylvania had these religious communities that seemed enormous to them, but that other people really didn't have, like the Mennonites, the Amish, the Quakers. For example, in Pennsylvania law, we have self-executing marriage contracts because Quakers don't have officiants. We've accommodated them in our statute book because the Amish, I know there are some debates about whether we need to have midwives being licensed nurse practitioners in Pennsylvania, but no, because we're protecting the Amish. So Pennsylvania was William Penn's holy experiment. In 1776, he put both a free exercise clause and an establishment clause in the Pennsylvania Constitution. What's interesting about that is, the framers of the Pennsylvania Constitution, they agreed in an establishment clause. That was pretty much a given. But there was actually a group of individuals who said there should not be a free exercise clause. And their reasoning, and think to yourselves if this sounds familiar to contemporary American politics, was that the Commonwealth of Pennsylvania, which was founded mostly by settlers from Germany and Sweden, was built upon Protestant principles and ideals, and that our governing documents should reflect that heritage. So that probably does sound familiar too, but sadly that argument lost. By the way, that group of individuals called themselves anti-constitutionalists, and they lost that argument. Pennsylvania got a free exercise clause. So anyway, this bill is introduced into Pennsylvania sort of as a test case with the belief that if these bills can survive in Pennsylvania, they can survive anywhere. And I don't want to go too much into the details of the religion clauses. I think you had a little bit of an outline before. But I will say, as a general matter, we know that the Establishment Clause prohibits government from establishing an official state religion. And under the Lemon Test, we know that laws are suspect under the Establishment Clause if they have either the intent or the effect of advancing or prohibiting religion. I'm going to leave the excessive entanglement prong for a moment. I also want to point out that even within the Establishment Clause, we know that in the Lynch v. Donnelly case, Justice Sandra Day O'Connor said, this Lemon Test is a little unwieldy. Let me try to think of a way to provide an analytic framework for applying it. And she created what was called the endorsement test. And let me just quote some language from that opinion. She specifically said, "The Establishment Clause prohibits government from making adherence to a religion relevant in any way to a person's standing in the political community. Government can run afoul of the Establishment Clause in two principal ways. The more direct infringement is government endorsement or disapproval of a religion, because endorsement sends a message to non-adherents that they are outsiders, not full members of the political community. And then, of course, disapproval sends the opposite. So it's this idea that under the Establishment Clause, what is bad, what is whether the bill has the intent or effect of attacking religion, but understand it this way. The question is, has the government either positively or negatively sanctioned a religion? Have they voiced their official approval or disapproval of a religion? I also want to point out one of my favorite free exercise cases, which is the case of Lukumi Babaluai versus Halea. This is fabulous not just because it involves Santeria. It's a generally fabulous case. But in that case, there was a question about whether animal sacrifice, according to the dictates of Santeria, was permitted. And the municipality argued that, look, my law is facially neutral. Ha, 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 it survives constitutional analysis. And the court in 1993 said, we reject the contention advanced by the city that our inquiry must end with the text of the laws at issue. Facial neutrality is not determinative. I think that's important in light of the model legislation's author's opinion that we've got to make it facially neutral to avoid the sticky problems of our First Amendment jurisprudence. The court went on to say the clause forbids covert suppression of particular religious beliefs, and that the free exercise clause protects against government hostility, which is masked as well as overt. So there is a set of laws, or a body of law, case law in the United States that says that facial neutrality is not determinative. If we know you're attacking a religion, that's a problem. And of course, I already gave you the history here where we had the co-sponsorship memo and the sponsor being pretty obvious about what she's doing. Now, in 2013, what has happened, these people are very savvy, so now they've realized that you can no longer put it in your co-sponsorship memos. It was in the preamble in Oklahoma, it was in the preamble in Louisiana, it was in the bill in Oklahoma, it was in the bill in Arizona, and yet you're still having public officials making statements saying that, we want to protect women in family law situations, especially women from the Near East or the Middle East, it's going to be harder to discern intent. My argument is as long as you know that this is the history of the bills, we've always got discriminatory intent. And finally, while my time is wrapping up, I do want to point out to you, as Osman said, these were bills, a solution in search of a problem. So I should tell you, so when you think about American laws for American courts, which by the way, to date, all but 16 bills have been under this model. So out of the 78 minus 16, I don't know what that is, I'm not very good at math. But most of the bills have been under this model. But they seem to suggest that if these bills weren't here, foreign laws would come into American courts and circumvent the U.S. Constitution. Well, as early as 1878, we have a whole body of law under the Free Exercise Clause that says as long as there is a valid and neutral law of general applicability, when that law violates, when a religious practice violates those neutral laws, that religious practice is not allowed. And I mentioned the date 1878 because that was the Reynolds case involving bigamy out in Utah. The court said way back then, 1878, religion's great, I love it, but criminal laws exist for a reason. And when religion interferes with criminal laws, we side with the criminal laws. There's a whole legacy of cases I won't cite here today, my favorite being the Peyote case, Employment Division versus Smith, but I'll give you a chance to review the body of law on your own. And by the way, if you're ever interested in reading more of my opinion about it, my manifesto to Harrisburg is available on the CARE website. But I just want to conclude by saying that even in the post-Oklahoma aftermath, these facially neutral bills, I believe, are subjected to constitutional scrutiny to the exact same extent because their discriminatory intent is obvious from the history. Thank you.
So we have a little PowerPoint. Let's hope it works, as usual. It's a wonderful privilege to be here, not only with WNL grads, but with colleagues from organizations that I've worked with on religious liberty issues for a long time. So I'm going to try to do my great friend and colleague Mark Drumble proud by shifting gears and talking about transnational law, or my version of it, in particular where we're seeing Islamic understandings of family law actually being applied on the ground. And basically what we have seen across the world in different pockets is an effort to accommodate religious understandings of family law, a movement that really has sprung up in Canada, in Great Britain, has existed for a very long time in Western Thrace since the Treaty of Lausanne. I'm not going to talk at length about Thrace, but I'll make a passing reference to it. I'd be happy to talk about it in questions. But in essence, this approach would substitute for the state's understandings of family law and the default rules that they would apply upon divorce or in the instance of a death, the understandings of various religious groups themselves. Now, these understandings sometimes get deference, specific deference from the state in systems of shared jurisdiction, like we'll see in Western Thrace, or I'll just mention in Western Thrace. But more recently in Great Britain, they basically are being given full force and effect, if you want to think of it, because the divorce that happens is actually being overseen by imams in the specific religious community. And what you're seeing is basically a divorce off the grid. Okay, a divorce that doesn't somehow come out of that community and back to the civil authorities. So one of the people in the British oversight authorities has talked about this as a quasi-jurisdiction, or a separate jurisdiction for divorce. Now, what entices me in particular are the risks to women and children from these movements or efforts to actually embrace religious understandings and to substitute them for the state's traditional oversight of women and children and marriage and family. And you know that family law actually protects people at two different junctures, two crucial junctures, both divorce and death. So I'm going to talk about both of those in different ways. I'm going to talk specifically about 4 questions. 1, how would custody of children be determined in these systems? 2nd, how will a woman's ability to exit a relationship be affected by these religious understandings, not only those that relate to children, but those that relate to finances? Then I'm going to talk very briefly and paint an empirical picture about the state's ability to provide and police family violence. And then I want to talk about what effect these kinds of religious understandings would have on the state's ability to protect vulnerable parties at the time of death, especially widows. And I'm going to focus almost exclusively on Great Britain's Sharia councils, where I'll talk about the fact that women stand to lose custody of their adolescent children and to face near certain poverty if one particular school of Islamic law, there are 7, one particular school of Islamic law is applied. And I'll show you how the other schools of Islamic law are not nearly so extreme, although they're not the ones that we're talking about applying, ironically enough. Then I'm going to talk about an empirical picture of violence in religious communities, but I want you to hear me to say that that means all religious communities, and that religious communities experience violence in the family just like every other community experiences violence in the family. And that we should worry about the collision of that pattern of violence in families with these understandings, because together they hold the promise that we will trap women who are in abusive relationships in those relationships because of these understandings. And then I'm going to talk briefly about how these religious understandings would affect the state's ability to protect women upon the death of their husbands. So you'll remember in 2008, the Archbishop of Canterbury called for a plural jurisdiction in which Muslims could choose to resolve family disputes in religious tribunals or in the British courts, sort of one path or the other path. And the Bishop of Rochester predicted that it would be impossible, he said, to introduce a tradition like Sharia into the corpus of British law without fundamentally affecting the integrity of British law, he said. Not only did religious leaders actually pop a brain cell, but lawmakers themselves did too. So you see Nick Clegg, who was at the time the leader of Britain's Liberal Democratic Party, who stated that equality before the law is part of the glue that binds our society together. They said we cannot have one law for one person and a different law for another. Now, query the fact that we have arbitration happening all the time where we have, in fact, one law for one party and another law for another. But put that aside. Now, there's a huge blowback after the Archbishop of Canterbury sort of comes out with this notion. But despite these sentiments, you see quietly 85 Sharia courts now operating in Great Britain. And as you see these sort of judgments and effects come out, I'll share some of them with you in a moment. What you have seen is some quiet pushback too, from not so quiet pushback from the government, talking about how is it do we reach into this quasi-judicial system and try to protect women and children as it continues to operate. And there's been an interesting set of bills, not the least of which is one by Baroness Cox, that still is pending, that would, for example, make it a crime for these quasi-judicial systems to, quote, claim legal jurisdiction over these questions. And in a new paper that I have, I'll show you that, in fact, their websites do claim legal, a jurisdiction, whether it's legal jurisdiction, a jurisdiction over these questions. So what kinds of substantive rules would they be applying if they get to questions like family law, which they themselves, the Islamic Sharia Council, for example, themselves say on their websites that they decide on behalf, or will help their adherents decide on their behalf. Let me pause for a second and note that I said that there were 7 schools of law. I'm presenting 4 of them here, but the 4 are the Sunni schools of law. In Great Britain, you have a Muslim population of 1.5 million people. But the important thing is that the overwhelming majority of them, 90%, apply the Hanafi rule of law. Now, the substantive rules that would be applied in the Sharia councils depart significantly from British background law, and I'll show you that in just a second. And that has serious consequences for women and children. In some schools, you'll see here that there's a strong presumption that the husband, quote, will get custody of the children in the event of divorce, as you can see with the Hanafi school. Now imagine for a second the catch-22 that a woman would find herself in if Hanafi custody rules applied. So posit a situation of domestic violence or even just harsh discipline of a child, okay? So if a father was harshly disciplining a child, discipline that outside of that community might be considered child abuse, and the wife says, this is not acceptable to me. And the Sharia Council actually enforces this norm in the oversight of their divorce or dissolution. The mother is going to, in effect, be powerless to help her child. If she stays, her child will be beaten, and if she exits, her child will remain with her husband. Okay, classic catch-22. But notice, too, that if you look at some of these other schools of law, very, very different outcomes. In fact, very progressive. Maliki would say, for example, or some of these schools would say that the children themselves get to express their wishes about who would, in fact, have custody after the divorce. So some of them are very, we would say, extreme, starting from the background rules that we would apply in our system, but some of them are actually much more liberal than what the U.S. system would be. But the one that we're specifically talking about is the first. Okay, now money scholars, including those in a volume that I recently contributed to that was published by Oxford University called Multicultural Marriage, actually have said, look, we would never, ever apply a custody rule from any religious tradition because that would be against American public policy. But they would be perfectly willing to apply the financial understandings of these religious groups. And I want to suggest to you that some of them would be just as bad as telling a woman you're going to possibly lose custody of your children. Why would they be just as bad? Because some of the rules that are going to apply at divorce actually come directly out of the Quran. But let me start with the first one. Generally, we already had a reference to the the Mar, which is, I always call it sort of like a parachute payment in the event of divorce. It's a deferred payment to the woman who's actually is very, very protective. It would protect a woman from the financial consequences or cataclysm of a divorce and potentially the death of her husband as well. So that has a great protective effect on women in the instance of divorce. But in this system, if the woman is not entitled to divorce because of the fault of her husband or some other reason, she is potentially required to pay her way out of the marriage by forfeiting the mar that has already been paid to her family and any deferred mar that she would be due. So she's not going to even have the payment that she would have otherwise had upon divorce, which is very protective of women. Beyond that, there's going to be no equitable distribution of the property, or what we would in family law think about equitable distribution of the property. The marital pie isn't going to go some to her and some to him. Instead, it's going to follow the title holder, much as it did in the United States before the Married Women Property Acts, for example, and other reforms of the equitable distribution laws. And what that means is title holder man is going to wind up with that property. Similarly, the Quran specifically says that the maintenance or the support of the wife is going to be limited to the adopt period, which is roughly 3 months after the end of the marriage. Every other person I've ever met in my life that pays alimony would say, sign me up, right? 3 months of alimony and I'm done. This is a gift, right? And then you have, in Great Britain in particular, in the Islamic Sharia councils specific procedural hurdles that women face that are different from men. For example, in one of these councils, the women have to actually pay more to file, 250 pounds versus 100 pounds for men. But more importantly, they have to have corroboration of their claims when men do not, because men do not require a second witness for the claims that they're making in that specific council. And I'll give you a good experience. A good example of an experience. Now, ask yourself, this was reported 1.5 years ago. A lot more is coming out about the way that the Sharia councils are actually operating. I can't vouch for it, but it is from a London paper. And this is a woman named Amina who sought the assistance of the Islamic Sharia Council to divorce her husband. I'm reading from much of the paper now. Backed by testimony of her daughter and 2 women shelter workers, Amina told the imam, Dr. Hassan, that her husband, quotes, beats me and the children. And the imam documented that abuse, including a beating that was so bad that it precipitated a miscarriage. Now, by the time that her claims of abuse were corroborated, after they were corroborated, the imam referred her case to a council of 7 imams who have to make the ultimate call on whether she's going to get a divorce. And that council of 7 decided that her husband needed another opportunity to reconcile with her before they would grant the divorce, because she did not have a unilateral right to get this, if they granted it at all. And at the end of the story, it said that Amina's fate remained in limbo. Now, here's precisely my concern. It is the intersection of these kinds of rules and the custody norms with the fact that there might be domestic violence in a particular community or household, okay? And again, I want you to understand me as saying that domestic violence, actually religious observance, if you go look at social science studies, is weakly protective of the adherence against domestic violence. And I can cite you a pile of studies. I'll show them to you. But domestic violence occurs in religious communities and religious families just as it does everywhere. And I'm going to show you a specific study that is drawn from 1999 by a group, Kulwicki and Miller, who examined the views of Arab American immigrants in the United States, nearly all of whom were Muslim in that particular community. And the researchers asked in particular women and men, quote, when would it be appropriate for husbands to slap their wives? Women in blue, you see, were more accepting of this practice than women in yellow across a range of circumstances, including when, the second set of bars, the wife disrespects the husband in the home when nobody else is around. That's interesting. But at any rate, to when the husband discovers that the wife is cheating, which is the last set of bars on the right. Now, perhaps most shocking, 18.2% of the women in this study said they would, quote, approve of the husband killing the wife if adultery was discovered. Now, men shared these views too. In this particular study, the group of men was too small for them to report a significant finding as to that belief. But in other studies, nearly a quarter, and in one study, as much as 2/3 of the respondents tended to justify wife beating because of, quote, sexual infidelity, insulting the husband in front of his friends, challenging his manhood, disobeying him, and a variety of other reasons. Now, if that gets you a beating, I'm in a world of trouble. Right? Because I'm not the manhood part, but just disobeying people, challenging people, not the sexual infidelity part. But in any event, the point I'm making is this is going to be a tough world to live in, okay? Now, clearly, some community members are actually complicit in this. They accept violence. And most disturbing is not just the community members themselves, but religious leaders. Now, this is true not only in this particular faith community, but in lots of faith communities. So I'm going to show you some Christian faith communities in a moment. But Professor Ayub has noted that South Asian Muslims in the United States, for example, in that community, quote, violence in marriage is generally condemned. But when it does happen, the religious community gives no clear consequences for the violent behavior. Okay. Now, this is true, again, of religious communities in the United States. This, you see on the left a study from 1981, where religious leaders were asked women who were abused in a particular Christian community were asked what their pastors had told them about that abuse. In that particular study, they received only religious advice, or since it was a wife's duty to forgive, they were told to return home or seek marriage counseling. In another study, 1988 study of, quote, conservative Protestant pastors, those are not my word, conservative describes particular denominations, they found that 92% of the pastors, by their own self-report, would, quote, never advise a woman to divorce an abuser. So this is not unique to any one faith community. Now let me shift gears and talk about the state's protection at the time of death. Just as women are worse off in many instances when religious norms are applied upon divorce, so too will they be in the context of estate distribution. Now, we know that the state protects the welfare of citizens through inheritance rules. But some of these religious inheritance rules take away the majority of the husband's estate and offer the potential of pushing the woman onto the state's social safety net. So let me be very specific about it. And these rules I've distilled from a number of authorities, and they generally basically say that the most that anybody who subscribes to this faith can actually will is 1/3 of their total estate. Any named heir, i.e. wives, cannot take under a will, so they can't be made special extra provision for under Sunni law. Islamic intestacy laws derived from the Quran cap the wife at 1/4 of the estate. That gets reduced to 1/8 if there are kids in the household at all, whether they're also the two of theirs kids in common or just his or just hers. But in the case of multiple wives, this gets reduced further and divided among the set of wives. Not surprisingly, you can imagine that British intestacy law just does it differently. I'll shorthand the slide. If you're super wealthy and you have an estate that's less than £450,000 and you have no issue with there are no issues surviving the man at his death, the woman takes the entire estate. Under £250,000, whoever else is left behind, she takes the entire thing. So let me make some of that very concrete, and I'll walk through some common scenarios very quickly. Let's assume that we have this man and his wife, and he also has 2 parents that survive him upon his death. Under the one school of law, or under this set of understandings, the most that she could take, if they had a £100,000 estate, roughly $161,000 US, is 25%. Okay, so she's going to get about $41,000. You can imagine under British law that comes out differently. She gets the entire thing. Okay, different fact pattern. Let's assume that he has mother and father surviving him, but instead we have up to 4 wives, which you can have, as I understand that, in a polygamous relationship. In that particular instance, father and mother are going to have special provision, again, made for them. The most the wives can take is 25% as a group, but it gets shared among them, so each one is going to get about 6.25% of the total wealth, which roughly nets out to $10,000 US apiece. Now you can imagine again under British law that comes out differently. Interestingly enough,
the British law wouldn't recognize the polygamous marriage.
No, interestingly enough, British law would recognize. There are authorities that say that they would recognize all 4 wives. So one of 2 things is going to happen under British law. Wife 1 will take either 100% or the 100% will be split between them, and if that happens, each one will take $41,000. I'll give you another fact pattern. Let's assume that there are kids. Let's assume 2 sons and 1 particular daughter. In that particular instance, provision will be made for mother and father. Wife will be capped at will be capped. I'll come back to that in a second. Sons are actually going to take twice what the daughter does. That's interesting all by itself. But in any event, wife gets 12.5%, which is going to turn out to be roughly $20,000. Under that fact pattern in Great Britain, you can imagine wife takes the entire thing. And then 2 more little scenarios, and then I'm done. John's going to give me a little bit of grace because he's my family law class. But in any event, same scenario, but this time we have 4 wives, and they're going to be capped at 3% of each, which is roughly $5,000 US. In Great Britain, as I said before, either wife 1 takes the entire amount, or the 4 wives split it among themselves. Now, this cap is so significant. I'm not responsible for the last. I'm actually not responsible for the PowerPoint, but I didn't make it. But in any event, I'm also not responsible for finding the last fact pattern, which one of my girlfriend's former research assistants did. But if we have in a state where we have husband dies, the only person surviving him are wife and a former freed slave. Wife takes 25%, and the freed slave takes 75%. Now, you can imagine that under British law, that comes out differently, and she takes the entire amount. Okay? Now, I actually believe, as I say in this new chapter, that the law can be neutral about who actually has duties of support for a woman or vulnerable dependents after death. I do. And what's supposed to be happening here is that the father or the brother of this woman actually picks up those costs. Thank you, John. Picks up those costs at the end. But what we're seeing, at least from two different authorities in Great Britain, is that the families in Great Britain actually recognize that there is a social safety net. And they're not doing that for these wives after their husband's death. And then that's an instance where I believe that the state cannot afford to be neutral. Because these women will be made destitute by rules like that. And I'll end on that note. Thank you.
Okay, I'd like to thank all of the panelists for basically sticking within the time frame. That's rare, and that's good. And we have about half an hour for commentary and questions. Monica, I'm not sure how it went in the morning panel, but you just open it up, or yes?
Can I make a comment?
Absolutely.
To the last presentation.
And if you want to, do you have a mic?
No.
Okay.
I can, because I find PowerPoint's a little simplified. I feel like I need to respond to some of the comments made about it. First off, as to the earlier point about the British, first off, all the cases, as it's pointed out, are the British system. So their views are quite a bit different. If you examine the family law, case law in Germany, in Canada, there is actually no real clear control over what those laws are. Interestingly, as the professor cites, Hanafi jurisprudence, actually, the reality is most Muslim countries have abandoned Hanafi jurisprudence when it comes to. So it should be noted that inasmuch as the insularity is pointed towards Hanafi jurisprudence, most Muslim jurists to this day actually have avoided Hanafi jurisprudence because of the very concerns that are there. Because most Muslim jurists realize that, for example, the onerous burden for a woman to obtain a divorce were actually unfair under Hanafi jurisprudence and have embraced Maliki jurisprudence. It has to also be noted that the provision of mahar, the provision of the balloon payment that was alluded to, one of the things that was not noted in any of the discussion about marriage is that marriage remains a contractual obligation under Islamic law. And so discussions about the mahar, the balloon payment, even intestacy have been sources of discussion within the framework of contracts. And if you look to the jurisprudence of the Ottoman Empire, the latest jurisprudence in Egypt and other Islamic countries, questions about intestacy and whatnot, as well as property maintenance, are also disputed and contained within property contracts. So it should be noted that, and then finally, with respect to the polygamy, which obviously is one of the things that's often trumped out about Islamic law, one of the interesting parts about the polygamy provision is that it's heavily dissuaded in most Islamic countries. In fact, almost the majority of Islamic countries have significant provisions that avoid polygamous marriages. Yet it's sort of trumped out as if all Muslims have 4 wives. I'm, by the way, married to 1 wife and have no intention of marrying any others. But what's also interesting about that polygamous relationship is that Tunisia, in a conclave of Islamic jurists in the 1950s, actually abolished polygamy consistent with the provisions of the Quran. So it's interesting that when inciting understandings of the Quran, understand that there are various principles of juristic thought and national practice that vary from it. What is notable is that Western nations are actually pretty bad at this. And one of the reasons why they're pretty bad about it, as you well pointed out, in these councils, they're established with imams. But historically speaking, there were actually state-appointed judges that would ensure conformity to Islamic practice. So the reality is that when you're talking about Islamic practice from the juridical understanding, that understanding was temperamented by the political authority of the state. Now you have Western procedures that are creating religious leaders as both the judge, jury, and executioner of what the law means. And that's one of the idiosyncrasies of Islamic law as it is understood today. So I want to put matters into a bit of context before people leave with the impression that some of these matters are eminently clear, undebatable, or altogether against women and children. Thanks.
Okay, thanks, Hamid. Another interesting point that both all the presentations bring up to some extent when we think about transnational communities and diasporas, how when communities migrate into different places, often individuals who see or articulate community understanding is not necessarily representative, right? So it's very interesting in that regard, too. Okay, let's open it up. Surely after that panel, yes, absolutely.
If we go open it up for questions, if people do have questions about how Sharia laws have entered the U.S. courts and how the courts have responded, I'd be happy to deal with it. But I'm going to wait to see what your actual questions are.
Yes, and on the topic of your remarks, the Save Our State and also Asma's remarks, then what transnational has is something that we talk about as well in terms of the role of courts and also the role of...
But I mean, obviously, these sorts of questions have made it into state family courts, and there's a whole body of law.
Absolutely. And in Canada as well. I'm Canadian originally. Okay, enough, please. Yes, sir.
Question for the professor. If I wasn't quite sure of how it's applied in England, but if a Muslim woman merely walks into a local civil court and applies for a civil divorce, would this whole thing be circumvented?
It would be, but I think part of the problem is that when you have a community inside of a community, frequently they don't know what options they have. They don't necessarily know. They have language barriers. They may have education barriers. They may have pressure from the community itself, which is something that Eilert Shahar and others have talked about, that there's no real option for these women to exit the community because it's the source of their identity. So it becomes very, very difficult for them to go outside of that. 2 points about that. One, the bill that Baroness Cox introduced in 2012 that's still there in front of the British authorities would not only make it a crime to falsely claim jurisdiction over these questions, i.e. to try to shut off access to the civil courts, but they posit a duty on the government to tell people in these communities what their options are. So to try to make sure that you don't have what's working out on the ground to be a quasi-judicial and separate jurisdiction evolving. Now, we do have experience with separate jurisdictions where the state, in fact, has said we will share jurisdiction with a religious enclave. And I mentioned Western Thrace, so I'll just tell you how that's worked out on the ground there. What you have is the right, the way it works is that 3 muftis actually decide all questions of family law for the religious group itself. They have a technical right to go to the Greek courts. But in one study that was done by a Greek family law scholar, what they found is that less than 0.5% of these cases were actually ever appealed to the Greek system, the Greek courts. They also found, you saw that slide about those 4 understandings of family law, they found precisely those things working out when the mufti decided these. No real support past the adopt period, the loss of custody, the fact that the women weren't going to necessarily have property at the end of it. And even though that would be grossly departure from Greek background law, you don't see that appeal.
Could I actually respond as well when we talk about the option of going to civil court? I know that there is, I believe it's a law review article here in the States called Getting the Get. It's about a woman's ability to obtain a Jewish divorce, and of course, without the husband's permission, she would go to a civil court. So this does occur in religious communities in the United States. A few years back, I think there was some publicity outside of Pennsylvania, by the way, about the Amish community and their system of justice, specifically how they sentence sex offenders within their own community, and that religious community's inability to go outside to a civil court. However, within sort of Muslim communities in the United States, I'm not convinced that these international barriers still exist here. For example, when we look demographically, we see not only are American Muslims amongst the most formally educated and affluent individuals, but that American Muslim women are more likely to be formally educated than their non-Muslim compatriots. So the idea that there are going to be language barriers or sort of legal sophistication barriers, I don't know that that applies in this society. I know that cases have come out. There's actually a report called Sharia Law in the Courts. You can Google it. I don't believe it's put out with the American Public Policy Alliance that created the model American Laws for American Courts legislation, but definitely an offshoot. And they try to enumerate like the top 50 bad cases of how Sharia law has entered into American family courts and bad things that have happened. And when you looked at that, this is actually the professor's last statistic talking about how few of the cases were appealed, and I believe it was race you were saying?
Western threats.
So in the United States, what courts will overwhelmingly do, and there's probably the worst come out of like Maryland and New Jersey, but when courts have said we're going to uphold this religious law, it's been pretty rare. Overwhelmingly, courts will look at whether any sort of contract, relationship contract, marital contract, was entered into voluntarily, whether women had equal bargaining power. It hasn't always been women. It's also been men on the short side of these deals, especially when men go abroad to pick their spouses. And they've generally found that contract where people do not have equally bargaining power are not upheld. And the few times when those contracts have been upheld, they've been overturned on appeal. So we've never had the American legal system unable to deal with sort of gender-biased Islamic law in the United States. I haven't found an example, and I have read those 50 cases.
Well, I just wanted to also point out, those same cases that are cited by the proponents of anti-Sharia laws, there was an ACLU report that went through them and noted that in each of those cases, the courts actually worked the way they were supposed to, precisely for those reasons.
Other comments? Yes.
Regarding the religious courts, do the triers of fact have discretion to bring in principles of equity, or do they have to be kind of strict constructionists?
Generally speaking, in the doctrine is called Istisam. It's a doctrine under Islamic law that there are various doctrines, not just, but in Islamic law, in the history of Islamic law, if you look at Ottoman practice, if you look at a number of different historical natures, first and foremost, any court, even Islamic courts, were always provident first with the letter of the law, right? So you take the letter of the law, you can take that approach, but there were always a principle allowing for equity. And what's interesting, although not mentioned, is that Hanafi jurisprudence actually endowed the principle of equity more than any of the other schools of jurisprudence. So inasmuch as their interpretation was more narrow when it came to questions of marriage, especially the amount of property, in reality, if you look at the judicial records of both the Abbasid Caliphate and the Ottoman Caliphate, especially with respect to issues of linear distinctions of law, they actually use equity to trump the law. So, and remember too that a religious council was only there to provide a religious interpretation, but a judge could always reject the religious interpretation in favor of a more equitable solution in the case at hand. What you're finding now in Western Europe, what you're finding in all these in many of the Western countries, is sort of an ad hoc approach. And remember too that these imams, self-declared imams and self-declared religious leaders in many countries around the world, do not possess the judicial education that was once required to even attain the rank of a mufti. Usually a mufti had to have 10 years of Islamic jurisprudential education of all the schools of law. And now they're sort of cherry-picked, and in many cases, like in Afghanistan, where I do a lot of work on looking at the convergence between women's rights and customary law, one of the fundamental issues is empowering women to actually know what their rights are. under Islamic law against the bulwark of customary law. So, for example, the practice in Afghanistan of trading little girls to resolve property disputes is still common practice. But in places where we have made efforts, and where the government of Afghanistan has made efforts to empower women of their religious rights, their rights to retain property, their rights to unforced marriages, women have become actually vocal in their regard. And in one particular instance that I was privy to in December, a woman, a religious leader, came to me and said, you are causing a lot of problems here. And I said, well, why? And he said, well, because these women are becoming very, very uppity. And I said, well, what exactly happened? She said, well, it turns out that she wanted to divorce her husband. I said, so what's wrong with that? He said, nothing. But she reminded all the male elders that the reason why she wanted the divorce is because he wouldn't sexually satisfy her. And I said, well, isn't it consistent under Islamic jurisprudence that if she doesn't receive satisfaction through her marriage, that she can have the right to divorce? And he said, yes, that's not the problem. We just don't like talking about it. So even in the context of a place like Afghanistan, empowerment is many of those issues, interpretation is many of those issues, and realizing that the actual practice is a lot more broader than sometimes simplified approaches might seem.
Other questions? Well, I have a question then. How do you folks see the conversation here has really involved the intersection of Sharia and American constitutional law and UK structures in areas like family law, for example. I'm curious about the intersections in the areas of commercial and contract law. And do those give rise to tensions in the jurisprudence? Do they give rise to tensions in the politics?
It's interesting that these anti-Sharia laws are getting a lot of attention in the context of family courts, but actually some of the most ardent defenders of Sharia law are actually financial institutions.
Right.
I mean, people
Chambers of Commerce.
Yeah, people do not realize that Islamic-based funds, Sharia-compliant funds, number in almost nearly $1 trillion. I mean, the Dow Jones has an index of Islamic funds. HSBC, Citibank, all have Islamic-compliant financial constructions that they've created. And so some of these proponents for anti-Sharia legislation are actually running up against financial institutions and saying, actually, we don't want that. You're actually going to deter financial transactions. So in that area, it's actually striking a different blow altogether.
Yeah, but what's interesting actually of that, so in other states, before the bill was introduced in Pennsylvania, the business community, so local chambers of commerce, were actually pretty vocal in opposing these anti-Muslim laws. Now, I know that the Pennsylvania bill itself created a carve-out exception saying when we talk about foreign laws, we're not talking about corporations. I mean, they had enough carve-outs to make it very clear they were just trying to demonize the faith. So it hasn't necessarily applied.
It wasn't demonizing faith, it goes to your point of demonizing a particular person.
People, yeah.
Because in my contracts class, I teach a law review article that talks about arbitration in the diamond market, and the rules that are often applied tend to be a combination of custom, Talmudic law, a variety of other sources.
Right.
And it's very interesting because I think in that context, when this is presented as a way to resolve disputes, for some reason the conversation about it is always a little more sterile or neutral. So I find it interesting how subject matter.
But I think you can kind of understand why the focus on Sharia law is focused upon family law, because most of the people who've expressed concerns about Sharia law talk about it in terms of we need to protect women and children, basically from Islam itself. That's sort of an undertone that seems to go through. And I believe it's linked to the perception that Islam is inherently anti-female. When we think about just the imagery that is involved anytime Americans discuss Islam, the veiled woman shows up as the #1 image. I will tell you, I love this symposium. I loved coming here today. I love the journal. I was on the journal. But when I looked at the program and saw the image of the female veiled in the American flag, I always wondered, why is that the first impression of what American Islam is? There's only been 2 Muslim women on this panel. Neither of us covers our heads, let alone our face. But if that's sort of what's out there in the society, in this atmosphere, well, because we don't think Muslims care about business, right? Muslims are big on, being kind of backwoods, camel riding, wife beating, whatever. It's outside of our framework of what the stereotype is.
Yes.
Can I ask you a question? And that is, you mentioned these banks. Now, you have, the Muslims do not want to take interest.
That's
And-
not clear
Yeah,
what that
but in
means.
some of these banks or whatever, if you have, we've been out fundraising. If you have money coming where it's there because they've got an interest for it, it's tainted money. And I'm wondering, did you have part of these banks, like is it American banks, that have got a Muslim section so that they don't have interest the way we would have interest usually in a bank? Or
Well,
why is-
I mean, I would challenge the assumption that there was no allowance for interest, and the Pakistani High Islamic Court has gone back and forth as one of the common law courts. Its decisions are published in English, so you would have briefs about this very question. And one of the fundamental questions that is still debated in the Islamic world today is whether interest is even acceptable under Islam, and whether the meaning of the word, which is the word rida in the Quran, really means interest. So I would challenge first the predicate that what that understanding is, because Islamic jurists don't agree on what interest is. Secondly, as to the question that you raised, yes, they do create filters. They also create filters that also say that if you are unwarranted risk can be prohibited under Islamic finance. That if you funnel your money through weapons, arms trading, pornography, any of the other prohibited items, they are also filtered away. So that's one way in which supposedly Islamic banks do it. Now, on to the question of interest, oftentimes what occurs is we will not charge interest, but we'll charge service fees that look like interest. So when you look at Islamic finance, I mean, they look facially appealing, but the reality is a lot of these constructions have only occurred in the last 20 years, and banks have become very creative, as we all know, with banking in general. They can become very creative in making something look compliant, and one way to do that is to create these filters, but the other way is to create additional avenues for what would amount to interest.
So they might put the really interest onto the loan at the beginning.
Or they divide an ownership risk. They created a different risk. So every bank does it, and they have different formulations, and they have different boards, depending on which bank you are, whether the bank, it's Citibank, UBS, banks in Dubai, a number of different ways in which they do it. And there is no clear ways that they all agree on it, because they create, again, bankers by their nature are creative, and this is one of the creative ways. But it should be said, however, that what is acceptable under Islamic law is the concept of a profit. So you can still have a profit. The question is, can you have interest? And oftentimes, the concept of interest as a financial instrument and profit are usually one and the same. So it's not as clear cut as people like to make it out to be.
Oh, I'll just make a couple quick points. I mean, one is, it's very reassuring and inspiring to talk about norms of equity overlaying legal rules, and I would like to have somebody like Hamid or any of my colleagues on this panel making these decisions. And I think it is possible for religious groups to evolve. We know that they do. We know that, for example, in my article, that in Morocco, you would never see the kind of outcomes reached under their code that you see reached in Western Thrace. But the fact that there are groups that have evolved away from such extreme outcomes as I presented to you does not mean that those extreme outcomes are not being reached in systems of shared jurisdiction in Western Thrace. And it does not mean that they are not, in fact, being reached by the imams in these Islamic Sharia councils. And I think what it means is that we have to look hard into these communities to figure out whether there are, in fact, minorities within a minority that are deserving of our protection, like the women and children in these communities.
And you have to look at the governance of those countries that exist. Because part of the fundamental issue that you imply is that there are institutions of governance that actually exist to deal with these issues, and whether they exist in the very areas that don't appear now.
I think that's right. I mean, we have seen polygamy, for example, in the United States evolved so that Mormonism, mainline Mormonism, has disowned it. But that doesn't mean that there aren't...
Let's get it back.
Well, that's my point. Let me finish. Let me finish.
Sorry.
And that doesn't mean that there are not splinter groups that are in fact practicing polygamy. My issue is not with any particular school of thought. My issue is with imams and muftis that are actually imposing these kinds of results on the communities that they are sort of vested with the authority to make these kinds of results with. And the Canadian experience is actually really instructive here. When they flirted with that in Ontario, the Prime Minister, Dalton well, they had a very long, complicated process to say where they took a former Attorney General, Marion Boyd, asked her to look at what was being proposed and what seemed to be being done with the Muslim Council there. She comes back with a report this big that had 47 different procedural protections that she believed would have to be in place in order for this system to be workable. About a dozen of them, were around these questions of voluntarism, voluntariness, coercion, the ability to exit communities, unconscionable results, all kinds of things that we take for a given in the United States courts. And she said we'd have to load them up so much. And where they landed was they said, nope, there's going to be one rule for all Canadians. And they rolled back the ability of any religious community, including the Beth-Din courts, which had operated in Canada for more than 100 years, to be able to apply their religious norms with their own religious leaders. They still said, hey, you can do religious arbitration all day long, but your religious leader has to apply Canadian law. Now, I'm not that extreme, but I do think that we have to look really hard at how big those departures are between what's actually being applied. And I would like to load up all kinds of equity. I would like to have these people applying different rules like the ones that Hamid and the folks here have described today. But it just isn't what's happening.
We have time. Yes?
I'm seeing sort of the negatives of the British system, but I don't really understand why they were able to implement that whole system in the first place. Like, what was the need that they saw to create these Sharia courts?
Well, I think... It's ironic. In both cases, and Chaudhry sort of touched on this when she talked about getting the get, is that the Islamic Muslim community has actually ripped a page from the Orthodox Jews, who have been actually making these decisions in their own Beth-Din courts for hundreds of years. And they did it technically under the auspices of the British Arbitration Act. Now, there was a time when the Sharia courts started to unfold, where it appeared that they were actually going to do arbitration and have those judgments civilly enforced the same way that the Beth-Din courts have been doing. But what's really unfolded is that they're making decisions, i.e. about custody in particular, that the British authorities say would actually make it impossible for those arbitrated decisions to be enforced by the state, because you're not permitted to arbitrate around that question in Great Britain. And then what you've seen is just sort of quietly off the grid, these things continuing to operate. And now Great Britain is tasked with trying to figure out, well, gee, do we stamp that out? I mean, one of the people wanted to say it was a crime for these things to operate. I think that's really difficult because, frankly, just like you see in the Jewish community, these women need the blessing of their religious leaders. Why? Because they are members of this community and they want to be members of it. So you have to find some way for these councils to continue to operate and serve a very important function to many, many people, their religious identity, and their ability to move forward in that community as a member of that community without sacrificing the protections that the civil system has put in place for women and children in particular, or any traditionally vulnerable person. So I think the British authorities are really pretty stuck at this point. Not to stamp it out, but to try to make sure that the good that can come out of it comes without the bad.
Can I actually respond?
Absolutely.
So when we talk about these communities, and actually the professor was correct, it came out of the religious community itself. So the community wanted these institutions. It was borrowed from Orthodox Judaism and Halakha or Jewish law, the way that those tribunals are run. But I do want to make it clear, because I feel as though this may have gotten lost. When I started my presentation, I put forth the definitions. I wanted to be very clear that I don't call these anti-Sharia laws because I don't think that they're about Sharia. I think that they're about Muslims and Islam. I don't believe, and I can't presume to speak for my fellow panelists, but I don't believe there's any mainstream Muslim advocacy group that wants Muslim tribunals. I think that may be something that we haven't really emphasized here. We're not asking for the rights for Muslims to get together and decide anything under Muslim law. And by opposing so-called anti-Sharia bills doesn't mean we're standing on any side of. I personally, I thought that Hamid spoke very eloquently about Sharia law. I don't believe that religious laws belong in courts. That's a personal belief, and by the way, not the beliefs of CARE Philadelphia or any CARE franchise, but that isn't what this argument about from my perspective. So I just want to make very clear that we're not advocating.
And I would affirm that. I mean, the majority of Islamic law doesn't even touch on matters that the state would even have any authority. Most of Islamic law regulates personal conduct that is largely outside the mechanism of the state. And Islamic history, Islamic legal history, has always demonstrated a propensity to avoid political entanglements, even from a court and a judicial standpoint, that is very similar and very much mirrors what we see in the United States today. In other words, a state institution that helps to enforce what might be a understanding of Islamic law, but not the understanding. What you see, and what the professor points out, I think rightly, is that you see insular groups, whether it be in Thrace or whether you see it in these backroom sort of quote-unquote Islamic tribunals in Britain, or in places like Pakistan, where women suffer. And it should be also be considered that gender plays a big issue in all of this. That patriarchal influences in Islamic civilization, in Jewish civilization, and frankly in the totality of Western civilization has always played an overwhelming role in all of these. And those prejudices are difficult. That's why, if you ask most Muslims today, in places like Turkey and Indonesia, which, by the way, have some of the largest Muslim populations, when they were polled by the Pew Research Forum on religion about whether or not they wanted Sharia law, even though they're overwhelmingly Muslim, they said no. And the reason why they said no is because they believed, like many Muslims in the Muslim world believe, is that Islamic law, many of those old principles of Islam, need to be really evaluated in the current context. And what's interesting is that Islamic law historically has set the bounds for a reformulation. The question is, do they have the courage, do they have the institutional backing, and is there a willingness to engage in that reinterpretation? But I fully endorse what the professor is saying. Otherwise, the last place, Western Thrace would be easy. Go to Afghanistan and work with the Taliban.
I think there was one. Do you want to ask a question?
No, it's
okay. Does anyone else want to ask their question? Does anyone else have a question?
I think I just want to make the point, just because the last two comments did focus on this idea of Muslims not wanting religious law, and I think, or the implementation of religious law to their lives, and to the extent that it can be enforced by civil courts. And I just wanted to echo something the professor had said, that a lot of women do feel the need for that, whether it be social acceptance or because they feel that's an obligation to their faith and their way of serving God. And so I come from more of the perspective of giving the widest possible latitude for the protection of religious exercise in public life, and I think the way that it has historically continues to be used in the American context is a perfect balancing of both of the clauses of the First Amendment, free and full exercise of religion, but also placing proper limits on that.
Okay, first of all, I'd like to thank all of the panelists for an outstanding panel that was both comprehensive, vivid, theoretical, and also very practical. And secondly, Monica.
Okay. So in closing, on behalf of the Journal of Civil Rights and Social Justice and Washington and Lee University School of Law, I'd like to thank all of our speakers for participating in today's event and for sharing their perspectives, for creating such inspiring, animated conversation around this topic. And I would like to thank all of you for being here with us at WNL today to engage in this topic. We very much enjoyed having you. Thank you all.